So good morning, everybody. I'm Kate White from Contact Cymru, and we're a charity that supports families of children with disabilities and additional needs of any kind. And that includes families of children with and without a diagnosis. So I'm here today with my colleague Zoe and Sophie, and also really thrilled to be running this webinar with wonderful guest speakers, Andrew Barrowclough and Steph Jones from HCB Solicitors. Um, as you know, the webinar has been recorded. After the session, we can send you a recording of that, a version of that. It will also have Welsh subtitles added to it after a little time, but then you can watch it in your own time. But thank you, a huge thank you to Andrew and Steph for today. So I'll hand over.
Thank you. Thanks, Kate. Thank you very much. So yes, as indicated, my name is Andrew Barrowclough. I'm an education law solicitor. I'm the head of the education law department at HCB Solicitors. We have offices, we've got 25 offices throughout the UK. I live in sunny South Wales and operate out of the Cardiff office. We've also got an office in Aberdare and Bristol as well, and we kind of cover that area. But 95% of the work that we actually deal with relates to English law as well, because education law goes throughout the whole of the UK. So we're solicitors in England and Wales. We're going to focus today, obviously, on the Welsh law and deal with that accordingly. But we operate in both areas despite being based in Cardiff. Steph is one of my qualified solicitors. She's been with me now 2 years, Steph, I think. So 3 the other day, and you said it's not that long. And I'm okay. Just the 2 years. And she practices and specialises in SEN law. So an education law solicitor, when most people think about that, they usually think of school admissions, especially this type of year. You'll have lots of friends of the family who are getting into their secondary school placements of they want, their choice. And sometimes a solicitor or an advocate will assist a parent who hasn't got into their choice of school to run what we call an admission appeal. You go to county hall, you try and get your kid in. Or sometimes people think about exclusions. If your child's been excluded from school unfairly, and you want to appeal against that exclusion, and it goes through an exclusion process. Those education lawyers do exist and do provide assistance for those families, and it's a very valuable resource. And we have a department that deals with that. What me and Steph deal with relates to special educational needs law, or in Wales, ALN law, and children with disabilities. And we help parents go from start to finish. So parents who don't have a diagnosis, much like your charity, okay, where parents don't have a clue what they're doing and are starting the process, we help them in terms of signposting them to experts, to the legal process, to charities, and we then assist them and hold their hand, frankly, through the whole thing. So we help parents to get an IDP. We discuss with them as to whether that should be a school-based IDP or a local authority one. I mean, skipping ahead a bit, but they should always be a local authority one. Don't forget about the school ones, they're of no use. And we then basically help the parents to argue the case. So we can provide as much support or as little as possible and as necessary. So sometimes we can make the relevant request, or quite often we prefer to. We start the process, we ask for the IDP, we then take parents through the process, get the draft IDP, we amend it at that point and make references to how it should be changed and improved. We assist parents in terms of asking for a particular school placement. If parents want speech and language therapy or occupational therapy in the IDP, we help parents to fight and get that in place. And then obviously the bigger aspect then is the Welsh tribunal system. And I'll explain that as we go through the process now. But we help parents to deal with that, to appeal, and to get the right support. As a starting point, what I like to say in terms of the law in England and Wales, in relation to special educational needs, additional learning needs, you'd be surprised to know that the law in Wales is actually brilliant. The law is very, very good and very strong. And there's specific reasons as to why the law in Wales is strong. It's because if you've got a child with disabilities and they require social care support, and you as a charity will come across this all the time in terms of what you do, and you have a parent who has a child who has significant needs and requires, say, 25, 30 hours of respite provision per week or direct payments. If social services assess your child and decide that actually they only need 10 hours per week of direct payments, there's basically nothing you can do about that. You can make a complaint to social services about the fact that you should be getting 30 hours and you're only getting 10 hours, and possibly you can try and put some legal pressure on them. But the reality is that you'd be making a complaint to the very body that you're complaining about. You'd be complaining to say, we think we should have 30 hours respite, we've only got 10, that's not adequate. The problem is that there is no adjudication service, there is no tribunal to deal with a dispute between a parent and a local authority regarding how much social care support you should have. Likewise, in terms of health in the UK, for children with disabilities who need speech and language therapy support, they go on a waiting list. For children who need a diagnosis, who are frankly destroying the house and are attacking their siblings, and they need an autism diagnosis desperately, they go on the waiting list. Because that's how it works in this country in terms of health provision. The healthcare law is weak. And if you're unhappy about that, you have to make a complaint to health. I mean, we wouldn't even dream of doing that because we're so used to going to A&E and waiting 8 to 10 hours that we wouldn't think about complaining because we're just so used to, oh, that's the process. I must stress, and also there's no adjudication service either in terms of health. I must stress that in relation to education law, that is not the case. And parents, because they fall into the trap of thinking that it's similar to social care and health, parents in terms of education law give up, or they allow schools and local authorities to mislead them, either deliberately or innocently, about what the legal position actually is. The legal position in England and in Wales, in terms of a child who has additional learning needs, is they have to have those needs met. Full stop. Doesn't matter about funding, doesn't matter which budget it comes from, doesn't matter if the NHS are swamped in terms of providing therapy. If a child needs direct speech and language therapy to deal with their language difficulties, then the child must have it for educational reasons. End of. They must have an IDP, they must have speech and language therapy. If a child needs occupational therapy provision or even physiotherapy, and it's an educational need, legally it must be provided. There are no circumstances where the local authority could say, no, we haven't got the budget or we can't provide that support. Legally, they have to do it. They have to provide the support. Similarly, if you have a child who needs to be in a smaller class environment because they can't cope due to the sensory demands of a mainstream secondary school, and they need smaller classes, and they need more specialist teachers, legally, it must be provided. Now, you might think, oh, that just sounds too simplistic. It's very well for you to say that. You're an education lawyer. You can argue it. I can't. But legally, that is the position. And what happens is that local authorities mislead parents. Again, partly because they don't understand the law themselves, and partly because the whole thing is a system, and they don't really fully understand what should be happening. And they tell parents, well, you'll never get a place at King's Moncton in Cardiff. You never get a place in St David's College in North Wales in Llandudno. We would never fund that. We would never fund a residential placement for a child who has severe cerebral palsy. We don't fund those placements. Again, all untrue. They do provide the funding. They do provide the support, provided that it's necessary. And that's the key issue. Okay? So in terms of this presentation, what we're going to deal with next, we're going to take you through the IDP process. The law in England and Wales was the same for a significant period of time. The 1996 Education Act was in place in England until 2014. And in Wales, the 1996 Education Act was in place until the 2018 new legislation. It's now called the Additional Learning Needs and Education Tribunal Wales Act 2018, but it's a mouthful, just basically the 2018 law. So the 2018 law changed the position, but didn't come into force until September 2021. And the main thing they've changed, in essence, is they have changed the word SEN to ALN. That's really the crux of it. They decided at some point that kids with special educational needs, SEN, they were considered to be picked on because they were special. That's what they said. That's what the research told them. There's an element of truth in that, I would say, in terms of kids being called special. But the focus, I would say, was more on that kind of aspect, that political correctness, as opposed to actually looking at how this would work in practice, which has caused more of an issue. So the 2018 legislation, it largely follows the old law, and it follows the law that exists at the moment in England in terms of EHCPs. The definition of additional learning needs, as set out within the legislation, is the term additional learning need. This is the boring legal bit, but I'll get over it as quick as I can. The term additional learning needs replaces SEN, and it refers to and defined as a child having a greater difficulty learning than others of their age, or having a disability which prevents or hinders them from using the facilities provided. So if you break your arm, that's not ALN, because it's a temporary issue. It's not a disability, and it's a temporary issue. If you have asthma, perhaps, but probably unlikely, because it's not going to affect you access to education per se. It's things that affect your access to education and cause them to have a greater learning difficulty than others of their age, or registered disability. So that's important as well, because you don't have to have a disability to have your difficulties recognized as being ALN. You can just have issues and greater difficulty than learning. So again, I get asked this question all the time to say, well, do I need a diagnosis of dyslexia to get anywhere? The answer is no. If your child is 10 and has a reading age of a 6 or a 7-year-old, then they have ALN. They're far behind. Although the reading rates in Wales are so poor anyway as a country that defines a lot of children these days, unfortunately. But the definition of ALN encompasses a lot of things. So ALN can be, there's kind of 4 key areas, okay? And it's important to understand that. The first one relates to cognition and learning. So you can have children who cognitively are lower functioning, who have what we used to call severe learning difficulties, or global delay, although global delay is a terrible diagnosis that really only applies to children under the age of 5, and children should grow out of that to be something more specific later. But children who have cognitive issues in terms of their understanding, their overall intellectual ability, those children will always experience issues in terms of being able to access the curriculum. So you have children with cognitive issues. You have children who still have cognitive issues but are intelligent, who have working memory problems. Most dyslexics have a poor working memory. And the easiest way they test that on a psychology assessment is they do the generation game conveyor belt test. They'll ask you to remember a cuddly toy, shapes on a chart, and you've got to remember it in the right sequence. They literally give you a sequence of numbers backwards and forwards, and you've got to try and memorize it. So you have working memory issues. Children can also have processing speed difficulties. Children with dyspraxia often have processing speed difficulties, because dyspraxia isn't just you're a bit clumsy. It is a motor planning issue. It is a processing issue. So children with dyspraxia often experience slow processing speed. That's an issue in terms of cognition. That's an ALN. And then you also have verbal comprehension difficulties. I mean, people will probably struggling, their brains will be hurting in terms of listening to me right now. And you're all using your verbal comprehension. I do talk quite fast, and I try and go as slow as I possibly can. But notwithstanding that, verbal comprehension is literally where this information goes into. Children with language problems struggle significantly in terms of verbal comprehension. So those are all specific issues that fit within your cognition, and it can all be ALN if you are impaired in terms of any of those particular areas. Then you also look in terms of cognition and learning at the other aspect, which is learning. So you look at a child in terms of their reading, spelling, writing, maths, written expression. Children with high functioning autism often have difficulties in terms of putting pen to paper and being able to write a page of text and express themselves. Obviously, spelling, numeracy, etc., all obvious in terms of what those issues are. They're all ALN. But cognition and learning is in many respects the obvious one. You also have, under the definition, communication and interaction. So again, children with receptive and expressive language difficulties, I must stress, those are not health needs. Because if you can't understand the language of the classroom, or you can't express yourself, you can't learn. So they are ALN. They are additional learning needs that relate to education. You also have, under the definition, social and emotional well-being. Huge issue these days. Children who have mental health difficulties, children who are anxious. COVID has not helped at all. I was having a chat with an expert recently, and the number of children who have the specific fear of other people throwing up and being sick has massively increased as a result of COVID. Germs, for example, have made kids completely paranoid and very upset. We also have a whole issue there in terms of children who are struggling to attend school. Used to be called school refusers. We don't say that anymore. Now we have the acronym EBSA, Emotional-Based School Avoidance. And it's now a real thing that is in itself an additional learning need. So you can have a child who's cognitively able, who academically is able, who cannot go to school because they simply cannot set foot in the school building because of their anxiety. And in those circumstances, they have ALN. Absolutely, they have ALN, without question. And then the final aspect relates to physical and sensory needs. You have difficulties in terms of fine motor, holding a pencil, holding a protractor, which, even though I'm old-fashioned, so I remember them a lot better, but they still use those in schools. If you have any problems like that, then those are all additional learning needs as well. Gross motor skills, if you can't run, jump, or have balance issues, that affects you in terms of PE. Those are all additional learning needs. And the other massive area that's always under-assessed, but is a huge problem these days, relates to sensory. You can have a child, again, who's high-functioning autistic, who academically is able and is just about emotionally holding on, but because of their massive sensory issues, they can't sit in the classroom and stay regulated. They need such significant movement breaks. Those children have additional learning needs. Those are all issues that should be dealt with by way of the appropriate legislation. So then you then look at what is considered to be additional learning provision. Additional learning provision is the support given to a child or a young person with ALN to help with their learning. And basically it's defined as anything that's different to the support that is generally available, generally given to learners of the same age. So that could be any reading intervention, any additional support provided, any additional one-to-one, any withdrawal support, peer learning, anything like that. That fits the provision and fits the definition of additional learning provision. So the types of IDP, there's two different types. There is the school-based IDP and the local authority one. Come on, Steph, Christ. So the types of IDP. The school-based IDP, pretty much every kid who has any additional learning needs and requires any additional learning provision should have a school-based IDP. Now, you'll probably all be thinking, my school refused to provide one. That's because they don't want to, because it's hard work to do, and because they don't understand the law. They don't understand that the threshold is so low. The threshold is literally at the point where I explained. Any additional learning needs, any provision made to meet the needs of that child qualifies them to have a school-maintained IDP. But what we really always stress to parents, and what you really want to get to, is the local authority maintained IDP. That's the most important thing to get. Now, the problem with a local authority maintained IDP is that local authorities are running around telling parents that they won't issue one, ever. And that's their position. So when the law was changed, Steph, you can bump ahead with me one, thank you. When the law was changed in 2018, or 2021 when it came into force, there's been research provided on this. At the time, there were about 60,000 statements of special educational needs in Wales when the law was changed. They envisaged that as a result of the changes, it would go up and there would be 90,000 IDPs because more kids would get an IDP. What happened is the number of IDPs reduced from 60,000 to 40,000 IDPs. So they got it wrong by 50,000 kids having this legal support. And the number of IDPs continues to drop because local authorities misunderstand their legal obligation. Within the Code of Practice, there is some reference to children who are looked after children. And looked after children should get an IDP. It refers to that, and there's a whole section on it. Local authorities have taken that to mean that the only kids who can get an IDP are children who are looked after. I know this because I go to meetings and I attend presentations, etc. So I went to a meeting recently in a local authority borough, who I won't name for the sake of it being recorded. But this local authority literally told my client in the meeting, only children in care get local authority IDPs, and the only reason to get an IDP is because from local authority is because your kid is in care, or if the child is in an independent school like Kings Monkton, for example. There was no other circumstance, and they said that's because the school should be able to make any provision for the child, and the child in question has EBSA and needs home tuition, needs alternative education environment, needs CBT, needs occupational therapy. So I said to the representative in the meeting, there's no way that any of this will be provided without a local authority maintained IDP. You cannot expect the school to do this under any circumstances. They didn't seem to understand the issue. They thought it was no issue whatsoever. Had another case recently where a child had a statement of special educational needs and it was converted into an IDP, into a school-based IDP. Again, shouldn't be happening. If you have a statement of special needs, it should always go into a local authority IDP. And that child was in a specialist autism base, a resource base. They still provided an IDP at the school level. The legal test as to whether or not to provide a local authority IDP is quite simple. The test is, can your child have their needs met from within the resources ordinarily available in a mainstream primary school? That's the test. So if your child can go to a mainstream primary school and have 10 hours of TA support, which is probably reasonable for a mainstream primary school to provide without a local authority IDP, if you can have 10 hours sporadic support, or if you can have a bit of reading intervention or a bit of numeracy intervention or a bit of speech and language therapy support occasionally, if you can have that intervention made, you should have a school-based IDP for a start. But if you can have that intervention made and your child is making good progress, then you don't need a local authority IDP. But if your child is not making good progress, is unhappy, is unsettled, and is making poor progress academically, socially, emotionally, physically, then they might need a local authority IDP. And the local authority IDP basically just provides funding or anything else that's necessary. So the funding from the local authority IDP could allow the child to have full-time one-to-one support, for example. Now, again, it's an old wives' tale that they'll say, we don't provide that anymore. Rubbish. If a child needs full-time one-to-one support, legally should be provided, and it should be specified in a local authority IDP. If a child needs direct speech and language therapy, if you have an expert report from an independent speech and language therapist that says direct therapy is needed, again, that should be provided via a local authority IDP. Same as occupational therapy, same as CBT. Or if your child does need to go to a more specialist environment, a smaller class, and it's an independent school, again, that can be fully funded via a local authority IDP. It is not true to say we don't fund that. Or what I often see is, oh, you pay the school fees of that independent school and we'll pay the top up. Again, not appropriate. If the child needs to be in a smaller class and a private school as a result, the whole placement should be funded via the local authority IDP. But they are reluctant to provide them and will try to not do so at every cost. So the IDP request is a two-part test. You've got to establish that the child has or may have ALN, which we discussed in detail in terms of what those areas are, and it may be necessary for ALP to be made by issuing an IDP. So again, the request in terms of getting an IDP is, as I said, it's a very low bar, because any child who has ALN and has any provision already being made, then they should have an IDP. The issue comes in terms of getting a local authority one, which we'll cover. But the relevant timescales are that the IDP request is made at week 0. Local authority then have 12. This bit is stupid. It's frustrating. The local authority then decide if the child has ALN and notifies the parents they do not agree if they don't, or they decide that the ALN requires ALP and issues an IDP by week 12. So you can make a request direct to the local education authority in terms of if you're in an independent school, or if in a local authority school, you make the request to the school to start the relevant process to try and get a school-based IDP first, then you can ask for it to be converted. Steph, I think that's right, isn't it? That bit always confuses me terribly because it shouldn't matter as to whether you're in an independent school or not. The IDP itself and the drafting of it, we've set this out in the slides. It should have in there this information. These slides are available afterwards, by the way, so I'm not, you have to read them in detail. I'm whizzing through a bit. It sets out the basic information, but the relevant sections are highlighted here. So you've got the description of ALN, which is additional learning needs, the description of ALP, additional learning provision. The IDP also has the additional learning provision delivered by the NHS, But again, I would almost always ask for the provision to be moved from anything that's in health to education. It's again something they might fight you on, but provision should be available within a school environment and should be educational. If it's health, pretty much it's always going to be, should be in education, unless it's something like medication. The IDP should also set out the placement in 2D, which could be a local mainstream school. And if you're not happy, you could appeal and ask for an autism base, for example. So if the local authority determine a school you're not happy with, you have the ability to appeal to the Special Educational Needs Tribunal. If you're not happy with the description of your child's ALN, you can appeal to tribunal. Or if you're not happy with the description of the additional learning provision, the support, you appeal. The purpose of the IDP, put it clearly, is it should set out within the description what the child's difficulties are, and then the document should set out how to meet those difficulties. So, for example, if it says in the description that they have language problems and difficulties in terms of understanding and speaking, in those circumstances, Section F should then include some form of speech and language therapy support, whether it's by way of the NHS providing programs and monitoring, or whether it's direct speech and language therapy provided by a speech and language therapist. Something should absolutely be set out within Section 2B to provide for the child's difficulty. And then the placement should be named in 2D. So if you're not happy in terms of anything that's in the IDP, you have the ability to appeal to the Special Educational Needs Tribunal. But only in relation to a local authority IDP. You can't appeal against the governing body IDP. So whatever they put in the one at the local level, with the school, you can't appeal. You've got to appeal within 8 weeks of the decision, and that can be extended by a further 8 weeks if you engage in the mediation. So there's potentially a 16-week time period after you lodge an appeal to tribunal. Appealing to the Special Educational Needs Tribunal is free of charge. Doesn't cost you anything. You can do it yourselves. Don't have to have a lawyer present, and there's also legal aid available. If you are a family who have low income and you qualify for legal aid, then you can go to an education lawyer who provides legal aid services. Unfortunately, we don't. We don't have a legal aid contract. We just do private work. But there are some firms who we can direct you to, and we can always provide the details. If your charity needs the details, we can provide those details, and then you can have that information. But the tribunal itself, there's no fee for lodging. Also, the tribunal doesn't award costs, which is a good thing and a bad thing. So if you lodge a case, you don't have to worry about having a big costs order made against you as a parent for the local authority's fees. It's very unlikely that the tribunal would ever award costs. Unfortunately, that also means that when you lodge an appeal and you win, you don't get your money back. You don't get your costs back. So any money you've spent on lawyers or experts, you pay for that. You don't get that money back at all. You have to basically forfeit that money. But in terms of winning the case, you get your kid into the right placement, you get your kid the right level of support, which they'll have indefinitely. The Special Educational Needs Tribunal in Wales can dismiss the appeal, they can make an order, and they can order the local authority to reconsider. The decision is received within 10 working days of the hearing. The tribunal consists of tribunal judge and 2 panel members. They have no connection to the local authority at all. They are entirely independent, and they, by and large, make fair and reasonable and good decisions. So the statistics in Wales we haven't had for a while, but the statistics in England are updated on a regular basis. The percentage chance of a parent being successful in tribunal in England is 99%. So the chance of winning your tribunal appeal in full or in part in England is currently 99%. It means local authorities lose nearly every single case they try and defend in tribunal. And there's lots of reasons for that. I mean, the main reason I would say is that local authorities don't know the kid as well as the parent, maybe. And if a parent is going to bother appealing to the tribunal and feel that strongly, then in those circumstances, they're usually right. And as long as they get some evidence and argue it correctly, then they're successful. As I say, the percentage chances in Wales are a bit lower, but that's because there's very few appeals and it's much more difficult to try to register it. Whereas in England, there are 16,000 appeals. So it kind of all levels out a bit better. In Wales, there's a lot less. And frankly, as well, the Welsh system and the Welsh tribunal process hasn't in the past been as good as it is in England. So the Welsh tribunal 5 years ago was not as good. And we had issues in terms of the particular, how can I put this whilst being recorded, the particular process in terms of maybe a particular judge or the general way in which it was dealt with. But what's happened in Wales is that the lead tribunal judge in England is a woman called Jane McConnell, and she's come across from England, and she's now the Welsh tribunal president. She's brilliant and has been for years and years and years, 15, 20 years. She knows her stuff particularly well. She's reformed the Welsh system. One thing I want to go back and explain, because it's something that gets missed and is complicated. So you can work with the school to get a school-based IDP. And if you ask for an IDP and it's refused, you can then go to the local authority. And if you have a school-based IDP, you can ask the local authority to adopt the IDP. If any of you have a school-based IDP, you should pretty much always be asking for the IDP to be adopted by the local authority, because there's nothing legal about a school-based IDP. If it's necessary to make provision, and if your child is struggling in school, everything's fine, then great. But if that was the case, then lots of people wouldn't even be here. If you don't have an issue, then everything's great, then stay with the school IDP. But if things aren't working, and if the child is still not going to school or is not making sufficient progress, then the next step is to ask for the local authority IDP. Because all you have to do is establish that the child can't cope with the existing resources and therefore needs that local authority input and needs that oversight. And the way that we normally do that is, in our experience, parents have spent years and years and years arguing with the school, because they're the kind of first people you come across. But the problem with that is that the school actually aren't to blame largely for the current situation. It's the local authority who have the money, and it's the local authority who have the resources in terms of specialists and experts, all those sorts of things. The funding mechanism in Wales is poor anyway, in terms of delegated funding, and most schools are just trying to do the best they can from the provision. Now, there are exceptions to that where schools refuse to acknowledge that the child has issues. But even then, the best way to tackle the process is to say to the school, look, you've done your best. You've tried to support my child as best as possible. You're not able to do so because you do not have the resources to do so. We therefore need to go to the local authority to get local authority IDP to get the right level of support and assistance that's needed. And that's the kind of the additional level that you can go to get that intervention. So you have an IDP, check whether it's school-based, local authority-based. Check in terms of whether or not it should be adopted by the local authority as to whether things are going well, or whether there needs to be additional provision put in place or support. If you're looking at appealing to the tribunal, you need to get it adopted by the local authority. Otherwise, you're going to be stuck. And that request, you can ask them to adopt it. If they say no, you can appeal. If they say yes, then you've got a local authority IDP, and you can ask for changes in terms of the IDP. So that's the most important part of the process. Apart from that, I think that pretty much covers everything in terms of the general process, and me and Steph are happy to answer questions. Thank you. Is that helpful, Kate?
That was absolutely fantastic. Yeah, we've got a few questions in the chat. I've added one as well. You might have covered it a little bit. But yeah, that was absolutely brilliant. Thank you so much. Shall we go back to the questions in the chat first?
Yeah, sure. And anyone else wants to add new questions, then please feel free to stick them in there. It doesn't matter how stupid you think they sound. This whole thing's a minefield, so feel free to put them in. And we're happy to have initial consultations as well. So if you want to speak about your individual case with us afterwards, me or with Steph, then you just contact us, contact the charity and come back to us or whatever. And we then schedule in a Zoom call or a telephone call, whatever works best for you. And we usually can go through your case 20 minutes, half an hour, go through all of it, look at where you are at the moment, give you that kind of initial advice as to what to do next. And if you want to then be a client of ours, then you can be. But yeah, I should also mention, I sometimes mention at the beginning, but forgot to, in terms of dealing with the boring legal stuff, is that I've been doing this for nearly 20 years. So this will be my 20th year. I know you wouldn't think it because I look so youthful, but the white in the beard is starting to give me away. But we've been doing it nearly 20 years. I set up the education department at HCB, and I think we employ 25, 26 education lawyers, special needs lawyers, remarkably, who just do this day in, day out in England and Wales, obviously. And I also have three kids. I have an 11-year-old daughter, an 8-year-old son, and a 6-year-old. And my 8-year-old son has complex autism. So I'm extremely passionate about doing this as well. I was doing this for 12 years before I had him, and I was passionate anyway. But it's just funny that I would end up with a child with additional learning needs who has very complex issues and has have a lot of support in a mainstream school.
And can I just say the passion comes through. It's a really exciting webinar, very bold and very, very much needed and appreciated. But I'll save my question till the end and we'll go back to, we won't say any names that are in the chat, but if we go back to 10 past 11, I don't know whether you can see the chat or do you want me to
I
read
can.
the...
No, I got it. I got it.
Okay.
You can get an IDP for a child who's in year 11. You don't need to have a statement. You can still get it in year 11, Steph, can't you? I think you can still get the support.
Yeah, you can still get the support in year 11.
And moving on to college. So the old system for moving on to college used to be called a learning and skills assessment, LSA, which was a terrible system. So the IDP process now lasts up until you're 25. So even if you're in year 11, you can start the process then to get a local authority run IDP. And then you can get the support in a college as well. IDPs don't stretch into university, but they do stretch into college, definitely.
Okay.
Next question, I'm looking now. 9-year-old has a local authority maintained IDP, 14 hours of funding for an LSO for 12 months due to be reviewed, and the LA may withdraw the funding because of because the LA may withdraw the funding because of budget pressures, and they wanted to go to a learning resource centre where they put the majority of their ALN funding through our mainstream school. Are being supportive. Are they able to do this? And if not, how do I ensure they continue the funding? I mean, if your 9-year-old who has 14 hours still needs the 14 hours, and that has to be provided. The budget doesn't come into it. It's irrelevant. They shouldn't even be mentioning it. It's not appropriate. Again, it's not like social care funding or health. It doesn't matter how stretched their budgets are. They have to provide the support. So if the 14 hours of support are still necessary, then they have to provide it. It should be put in place. And in terms of any learning resource centre, if you're happy with a learning resource centre, then great. But if you want to have additional support within that, then that's fine. But you can also transition into a learning resource centre, and then you can ask for the IDP to specify that when the young person then goes into mainstream lessons, they have one-to-one. So the IDP can be specific. The IDP can say anything you like, just like a statement of special needs. It's another kind of old wives' tale in terms of this process that IDPs can't be specific and have to be more vague. That's not the case. Although they are drafted in a more vague way these days, and in the kind of conversion meetings from a statement to an IDP, you spend a lot of time talking about all the things you love about the kid, as opposed to what are the issues. But they still are legal documents that have to be provided in a quantitative and specific manner. So there's no reason to draw the 14 hours if it's considered still to be necessary. The next question, I'm trying to read them so that it's not just bad television per se, in terms of just reading it as opposed to not reading it out. Our DECLO has advised that it is not the NHS's place to make recommendations for educational provision within the IDP, and this position is influenced health staff not to specify any interventions, therapy or support, especially if they cannot provide it themselves. What are the legal obligations of health professionals under the ALN code and relevant legislation in Wales regarding contributing to IDPs? How can I effectively challenge this stance and ensure that the IDP accurately reflects all necessary provisions, even if they may translate into a responsibility for the local authority to provide via education? That's a very good question. The NHS should provide reports which are quantified and specific, that set out the child's difficulties and the provision required. When the NHS provide their reports, they're doing so on the basis that they have their NHS hat on, which is often different to education. So that's the first caveat and the kind of first get out I'll give them in some respects, because they can say, well, we're looking at this from a clinical perspective in terms of how to meet this child's language needs. But actually, the educational perspective is different. So that is part of an issue. The problem as well is that it's the responsibility of the local education authority to assess a child properly and to provide the right level of support. So the IDP should include speech and language therapy provision that's been commissioned by the local authority. And it's therefore their responsibility to make sure that it has an educational aspect. But then the NHS are the ones who do the assessment. So there's a mismatch between the two things, which again, I'll give them a bit of credit for, is actually not the NHS's fault per se. What I don't accept at all is how speech and language therapists in the UK have become speech and language program writers. They have no longer seem to be therapists because they don't actually provide an awful lot of therapy, which is an issue. So a colleague of mine, I remember this so clearly, it's about 13 years ago. He went across to America and he met with a woman there called Professor Erie, who advised Congress in relation to speech and language. America is brilliant in terms of autism provision and language provision. They provide loads of therapy. They provide the insurance companies, if you have one in America, you're lucky enough to have one, they provide a massive pot of cash to support children in terms of autism. So you can provide therapeutic remedies at home. And Professor Erie, when my colleague explained the system in the UK, whereby we draft programs, turned round and said to him, I didn't realize that the UK had become a third world country in terms of how we deliver therapy intervention. So it's a difficulty because the NHS generally will not recommend direct therapy, kind of ever. So in terms of the question, it doesn't matter what you say to them in terms of saying about their legal obligations, their professional code of conduct and the NHS's professional body basically tells them not to recommend direct therapy. It tells them that there are other ways to do it and it's better to write a program and get someone who's largely untrained to deliver the program throughout the week rather than providing direct therapy. It's a massive problem because other countries don't do it that way. America don't, Dubai don't. They pump kids full of lots of therapy. We don't here. So you're never going to get the NHS to change it. So the only way to really change it is to go to an independent speech and language therapist who has broken away from that kind of working for the NHS and who is therefore quite often more willing to recommend what they think the child needs, which might be direct therapy. And what I can assure you on is that the Special Needs Tribunal do order direct therapy. If they see a child with a language disorder who's made no progress in 3 years, they're not going to allow the kid to continue to get no therapy and just to bump along. They're going to probably recommend direct speech and language therapy. So the tribunal is kind of the only backstop to make them do it. Unfortunately, making the NHS be more specific or quantified is never going to work. And I couldn't get them to do that. You'd have to just go to the independent sector. We have independent professionals who we work with in terms of speech and language and OT in Wales and in England. So we can give details of people that we recommend, who you can then instruct. And we can give those details to you, to Kate and Zoe, so that you have that information, so that you can have a pool of experts that we work with who can help. And those experts may also be able to do a webinar for you as well in terms of speech and language, for example. I know that they'd probably be interested in doing that. Next question is, what do you do with LA do not support an IDP and not support a child with ALN whatsoever? I mean, you can make the relevant request. You can ask them to issue an IDP. If they say no, you can go to tribunal. The backstop in that respect is always to go to tribunal. Someone asked, and I had an issue as Wales is not accepting English SEN. What can be done about this? That's another good question. So sometimes if you've got an education, health and care plan in England, and then you move across to Wales, Wales might say, we don't accept that the child has additional needs, and they could make you start all over again. The problem is that the English and Welsh system do not actually cross over at all. They're completely separate laws, which is ridiculous. You know, it's completely ridiculous. The difference in terms of just driving to one side of a road to another, you could be in a different country. So the law in England is totally different to Wales in terms of the tribunal system and in terms of the ALN or SEN provision. So unfortunately, there should be, but there's no conversion process from one to the other. So if you move over with an EHCP and Wales, the Welsh Authority says, we won't adopt that EHCP, we won't start the process ourselves, we're not going to deal with it, then you have to appeal to tribunal and start from the very beginning in terms of requesting an IDP. You can't start halfway through. Someone asked in terms of when you can and can't appeal. You can ask them to issue an IDP. Then you get a right to appeal. If they say no, you can appeal in terms of the content of the IDP as well. The old system used to have the assessment process in it, and you also could appeal if there was you made a request for an assessment. That process is now gone. They don't have assessments anymore. They just decide whether to provide the IDP, and then they should collect appropriate information as part of the IDP process. Someone else has asked, if a child is not in school and is excluded and the LA is saying no ALN and therefore they have to go to the tribunal, which could take 5 months, are the LA responsible for providing suitable education in the meantime? They're telling me that they don't, as the child is excluded from an independent school. So they tell me it was my choice. I mean, none of that's true, basically. If your kid's been excluded from an independent school, if the child is not in school, they should be providing alternative educational provision. That should be an offer of an alternative school. So it could be an offer of mainstream school, which you don't want, or it could be education otherwise than in school. It used to be EOTAS, now we call it EOTIS. In school, at school, I don't know why it changed, but it's EOTIS now. So you can ask for EOTIS if you can establish that medically your child can't attend school. You get the GP to say, this kid's too anxious to go to school, that helps. And then you can get into the medical tuition service. But if it's just a kid in terms of straight being excluded, then in those circumstances, they should be providing some educational provision. It's irrelevant whether you've been excluded from an independent school or from a mainstream school. Someone else is asking some admin-y things. Is the school IDP different from the LA IDP in terms of layout and structure? Good question. Every local authority has a different, shouldn't do, but often has a different kind of process and a different IDP. So yeah, it can be different, but the school within the local authority should be the same, should be similar. And part of that is the problem that you don't really realise whether you've got a school-based one or a local authority one, because it's so hard to work out from the information you have. Someone's asked, what do you do when a child has a senior consultant medical diagnosis preventing attendance at the mainstream and a consultant-driven medical recommendation for homeschooling, and the LA and school fail to provide any education and provision whatsoever to a child with a long-term medical disability for nearly 3 years? I mean, I would say sue them, basically. But I'm a lawyer, I would say that. But yeah, that's just unlawful. If a child is medically unable to attend school, in terms of the question being asked, then you should get additional educational support. You should have, you can sue them basically for not complying with their statutory obligations. If a child medically can't go to school, there is provision within the law that requires them to provide alternative educational provision. It's separate to the whole tribunal and IDP process. But yeah, they should probably also have an IDP if those are the circumstances. Someone's asked, saying, my child, age 6, diagnosed with ASD, attends a great mainstream school. They support her needs. They provided ELSA, Lego therapy. She has OT input on the waiting list for Ed Psych. She has a one-page profile in place. However, they are refusing to put an IDP in place, as they say her needs are currently being met with the provisions. How would you recommend we proceed with regards to pushing the IDP? My concern is that new class in September, we're starting from 0. Yeah, and if you've got additional learning provision, i.e. ELSA and Lego therapy, movement breaks, OT input, then that qualifies as additional learning provision. Clearly, that child has additional learning needs. You should absolutely have a school-based IDP in place. So you can make the request for an IDP, and they can say yes or no. If they say no, you can appeal. But I would strongly suggest you try and get one, because that arrangement is only working because of additional provision, and that's the definition. Having a one-page profile doesn't mean anything. Because the reason they don't want to issue an IDP is that a school-based IDP binds them to do something. It sets out issues in terms of needs, and it says it will have in there ELSA, Lego. They don't want to do it because then they're in the hook in terms of having to continue to do it. But that's the whole reason why they should do it, because you don't want them to stop doing it because they run out of funding, or because things have changed, or because, as you say, new class in September, everything goes wrong. So yeah, you need to make sure you get and make the request for a school-based IDP in the first instance. Someone's asked, can you give any insights about how to collect evidence of ALN and determine the ALP needed? We're struggling to get assessments from an EP, for example. No mention of, I can't see the rest of that, but OT or SLT from school. We are looking at privately funding, but should education be providing this? How can we secure and go about securing assessments? As I said earlier, we've got experts we work with. You definitely can't rely on the NHS or the local authority to do those assessments because the waiting list is huge. And even if they did do the assessments, you'd come across the issue that the person indicated earlier, which is the assessments wouldn't be very quantified or specific anyway. So the recommendations from the professional would probably be so generic that they could be provided in a mainstream school, and therefore you wouldn't need an IDP. So you want to go to experts who make quantified and specific recommendations. Again, we've got experts for all seasons because we do this so often. So we've got experts in terms of OT, SALT, specialist teacher, educational psychologist, clinical psychologist. We can provide you with details of all those people if you need them. Someone says, what is the full responsibility of the LA if they maintain your child's IDP? Can they fund specialist support in another county, regardless of age? What a local authority of reference lacks specialist OTs that are qualified in sensory integration. Can you request that these assessments are carried out regardless as part of his LA IDP? They can fund specialist provision in another county for sure, regardless of age, up to the age of 25. It's a good question in terms of the responsibility question. If an IDP says in the provision bit that a teacher has to hop on one leg for an hour every day in class, then the teacher has to do it. So the more quantified and specific the IDP is, the better. If it says 1 hour per week of direct speech and language therapy, the local authority have to do it. And the local authority and the IDP, if it's a local authority IDP, this is interesting as well in terms of the dynamic. The IDP binds the local authority. It is a legal document between the child and the local authority. You as parents are not involved in that process. The school are also not involved in that process. The school often deliver the input and provide the support, but legally, it is the local authority who are responsible. So if the school are not doing their job properly and not providing the one-to-one they should be that's set out in the IDP, the school aren't actually acting unlawfully. What happens is the school are making the local authority act unlawfully because the local authority are the ones responsible for maintaining the IDP. So in those circumstances, it's the local authority who are failing in their statutory obligation. But from a practical perspective, the school are the ones obviously not providing the right level of support. Someone's asked, says child has an LA IDP. The LA missed the yearly review deadline for more than a month. The LA doesn't engage with us. What's the next step? In those sorts of circumstances, you could write them a pre-action protocol letter. We call it a PAP, which is a legal letter that we would write saying you haven't complied with your obligations to have the IDP review within a year. Legally, you have to do it, otherwise we'll sue you. And they'll probably then do it. So we call it a PAP. So we can do those. We can do those letters if necessary. But I could say to you, just shout at them louder. But legally, if they don't listen, then that is the legal position. As you say, there has to be a review every year. Someone says, can you speak on moving a primary school child to a different school in a different city? Both the school maintained and local authority maintained. You can definitely do that. If you've got a local authority IDP, for example, you're in Cardiff and you decide to move to Caerphilly, then the IDP does need to transfer. So Caerphilly then decide whether they will adopt the IDP as it is. So it's not as simple as that. If it's a school-based IDP, the school-based IDP doesn't mean anything anyway. So the one you move to Caerphilly doesn't mean anything. So you just have one here, you have a school-based one, and then you ask the Caerphilly school to do it afterwards, and they say yes or no. But there's no legal process per se. But with a local authority run IDP, there's a proper legal process that the new local authority have to decide whether or not to adopt the IDP within a certain period of time and take it on. If they don't take it on, then you can appeal to tribunal. Someone just says they attended the Kings Monkton seminar, the session in Kings Monkton in 2014, and we were able to secure funding. Oh, thank you very much. That's good to hear. Always nice to hear success stories. And someone else says the school won't respond to email requests for meetings with the ALN Co. We're only allowed to email school to request staff meetings, so I don't know how to move forward with the school. My child has no diagnoses and hides their struggles at school, academically bright, very distracted, dealing with emotional-based school avoidance, dysregulation after school. I'm unsure what support school could provide. would like to be able to speak to the ALN coach. Should I contact the local authority direct? Yeah, if your child is not making progress and you're not happy, and emotionally and socially they're struggling, then in those circumstances, you can ask the local authority to provide an IDP. That's what I would suggest in terms of the next step. It's kind of the only thing you can do, really, if school aren't engaging with you. You need to go to the next stage. Someone asks, what about where are we? What about LAEP reports versus private reports? Are they going to be the equivalent, or is it like the NHS SALT example? And a private report isn't beholden to a particular. The private report basically isn't restricted in terms of limitations. That's a very good question as well, because one of the old wives' tales in terms of this process is that if you have a private report, the local authorities say they don't recognise it. They say, oh, we don't recognise that private speech and language or OT report or head psych. We don't recognise that it exists, and we don't recognise because it's not one of ours. Again, legally not appropriate. Those independent professionals have got obligations to their professional body. There's no circumstances which means that the local authority should disregard private reports, and the Special Needs Tribunal does listen to private reports. And yes, private reports, in my experience, are more quantified and specific than local authority ones. They shouldn't be, and you do get some local authority ones that are very detailed, but generally private ones are more detailed and more specific. Someone's asked in terms of having a chat, which we can definitely do. Someone else has asked, I don't know why my smartphone does that, goes on and off, my speaker. Someone else asked, is it likely that the tribunal will order direct speech and language therapy for a child who has NHS reports describing a high level of need, but no recommendation for direct therapy from either the NHS or private therapists? Specifically, the NHS will not specify direct. Is a private report always necessary to secure this provision? Or are there circumstances where the tribunal might make this order based solely on a demonstrated need? That's a very good question. So the Special Needs Tribunal are an independent body. The tribunal judge is a lawyer, and the panel members are experts in their field. They might have been a previous speech and language therapist in a different life, or an educational psychologist. The Special Needs Tribunal, however, is an evidence-based tribunal. So they absolutely cannot order direct speech and language therapy just based on the assessed level of need. They must have an expert recommend that it's necessary. So you have to get expert advice. I was in a tribunal hearing yesterday on a case where the parents tried to do it themselves. And reading between the lines, that's not always the best thing to do. And we came on quite late on, and the whole process was a bit of a mess. And they were arguing for their kid to stay where they were, but they didn't have very much evidence to do it because they didn't follow the advice in terms of what evidence to get, which created an issue. And they were arguing the case based on common sense, which again, from a parental perspective, is perfectly logical to do that. But actually, you have to have evidence. So no, the tribunal will never ever order direct therapy just based on assessed level of need. You need a private expert to recommend the higher level of support that's necessary. Someone says, my child's IDP is a LA maintained IDP, but the school are writing it, preparing it, reviewing it, doesn't matter. Someone else says, ours is the same. The school always write it and send to the LA for review and approval. And someone else says, and the reply to that is it's all done at the school level. I'm not aware if the LA even knows what's in it. Actually, that's fine. That's okay. Because if it's a local authority IDP, the school arrange the IDP meetings, the yearly review, and then they ask you sit down with the school and you suggest changes that might be necessary to the IDP, and then it goes off to the local authority, and then the local authority decide whether or not to agree to those changes. Local authorities pretty much never come to IDP review meetings because they can't. So one of the obvious examples I had previously is that in Hampshire, I think they have 1,000 EHCPs or something. In England, they've got 357,000 EHCPs in England. And the number of local authorities, I think Hampshire actually had 4,000. So about 4,000 EHCPs in Hampshire. And they've got 3 SCN officers. So they can't come to every single yearly review meeting. They can't do it. There isn't enough time in their diary. So they'll never come to the meeting. But as long as it's being properly ratified by the local authority afterwards, that's fine. The only time they ever do come to the meeting, I find, is when there's phase transfer. So it doesn't happen very often. And someone else says, who should be in attendance at the IDP review meeting for both school and school and LA maintained IDPs? Which department is responsible for adding transport arrangements for a child in special school into an IDP, educational or transport? Each department says it's the responsibility of the others. The transport, I don't know if it's changed, Steph, but I'm not sure if it should be in the IDP. Should it be specified now?
Yeah, there is a travel arrangement section within the IDP, so there can be details included in the IDP. But ultimately, if the school is named in section 2D and the local authority haven't said otherwise, transport should be funded by the local authority. And it's up to the education department to liaise with the transport team then, in regards to actually, put an application forward in regards to what mode of transport needs to be provided to the child, depends on their needs. So yes, for them to liaise with each other essentially to arrange that transport, but it can be included in the IDP, the details of the transport.
But it's not legally, I mean, you can't appeal based on a certain type of transport, but legally the local authority have to ensure that they provide suitable transport to the school in question that's named in the IDP. So you can get in an argument then as to whether there should be an escort, for example, and whether appropriate transport is in place. And some local authorities have internal appeals in terms of transport as well. I think that's it. Thank you very much to anyone. Like I say, if you want to get in touch, then give us a shout. We're happy to help. Otherwise, thank you very much.
Oh, can I just say a huge thank you to HCB for providing this webinar today. It's been absolutely brilliant. And thank you for everybody for joining us as well and asking questions in the chat. If your question hasn't been answered, I'll go through them and I'll send them on to Steph and Andrew after this, and I will share with everybody what the responses are. So just to let everybody know that who's booked on, we will email you as well after this, asking you to respond to the survey. You might have done it already in the chat, but we're asking you to respond to the survey so we can get your feedback, but two, we want to tell you also, how we can support you from contact. So we'll send you a bit of information about what our charity does as well. And I've got one question actually for Steph and Andrew. Do you know anywhere where parents, professionals can actually look at good examples of IDPs?
We can always get one that we've provided that is redacted.
Yeah, I just think that's been missing all the way through this process. The ALN Code of Practice, which is the guidance around this, the new system, was really lacking in IDP examples. And I think, for parents, looking at a really good IDP gives you a good idea what your child's IDP should be looking like, or even local authority IDP. But absolutely, thank you so much, everybody. I'm going to stop recording now. Okay, just 1 second. And if anybody's got any questions for us, you can speak.
She is absolutely mortified that local authorities in Wales are telling parents that you can't get a local authority IDP. As at the tribunal president level, she's spoken to them in user group meetings to say to them previously, what on earth are you talking about? This is nonsense. They're not seemingly listening yet, but she is trying to her best to assist the system in terms of the tribunal process and at the kind of ground level.